An Introduction to Constitutional Law, 100 plus Supreme Court cases everyone should know, by Randy Barnett and Josh Blackman. Griswold versus Connecticut, 1965. Following the New Deal, the Supreme Court applied the presumption of constitutionality when reviewing state and federal legislation. This approach severely limited judicial scrutiny of laws that were challenged under the Due Process Clause. However, U.S. v. Carolene Products in 1938 recognized two ways for a challenger to obtain meaningful judicial scrutiny of a law's constitutionality. First, as explained in the body of Carolene Products, outside of footnote 4, the presumption of constitutionality could still be rebutted. How? Litigants could present factual evidence showing that a law was irrational, arbitrary, or discriminatory in a particular circumstance. This approach is consonant with Justice Harlan's Lochner dissent. Second, under footnote 4 of Carolene Products, the presumption of constitutionality would not apply at all in three situations. First, if legislation violates an express prohibition of the Constitution, such as those in the Bill of Rights. Second, if legislation restricts those political processes which can ordinarily be expected to bring about repeal of undesirable legislation. Or third, if legislation adversely affects discrete and insular minorities who cannot protect themselves in the democratic process. Today, the court does not apply the specific footnote 4 exceptions directly to decide cases. Instead, modern due process and equal protection doctrines generally follow the theory behind footnote 4. 17 years after Carolene Products was decided, Williamson v. Lee Optical in 1955 foreclosed the first type of factual challenge to a law's rationality. Litigants could no longer rebut the presumption of constitutionality with evidence. This Warren Court decision applied only minimal rational basis review for rights that did not fall within footnote 4's exceptions. Through this move, the court was able to shield most economic regulation from heightened judicial scrutiny. How? Because the rights enumerated in the Bill of Rights were largely non-economic. Lee Optical's approach requires courts to accept any hypothetical or conceivable rationale a legislature might have had for restricting liberty, whether or not that rationale had in fact been considered by the legislature. Conceivable basis review, as we call it, is more consonant with Justice Holmes's dissent in Lochner. Following Lee Optical, litigants could only avoid the presumption of constitutionality by invoking doctrines based on one of footnote 4's three categories of exceptions. Then, 10 years later, the Warren Court started to expand the first exception. Starting with Griswold versus Connecticut in 1965, the Supreme Court held that in addition to the express prohibitions in the Bill of Rights, there might also be a narrower scope for operation of the presumption of constitutionality when certain unenumerated rights were violated. One such right was what the court called the right to privacy. Connecticut long had a law on the books that criminalized the use of contraception. The law also prohibited counseling couples on how to use such products. There's some debate about how often the law was actually enforced. So with a test case in mind, the Connecticut Birth Control League opened a Planned Parenthood clinic in New Haven in 1961. Estelle Griswold was the executive director of the league. Dr. C. Lee Buxton, the chairman of the Yale University Department of Obstetrics and Gynecology, was the medical director of the clinic. In November 1961, Griswold and Buxton deliberately violated Connecticut's law so that they would be arrested. They were each fined $100. On appeal, the Supreme Court reversed their convictions. 7 justices found that Connecticut's prohibition on the use of contraceptives for married couples was unconstitutional. Chief Justice Warren and Justices Douglas, Clark, Harlan, Brennan, White, and Goldberg. Justices Black and Stewart dissented. Justice William O. Douglas, the author of Lee Optical, wrote the majority opinion in Griswold versus Connecticut. First, he rejected any argument that Lochner v. New York was a guide to deciding Griswold. He wrote, quote, "We decline that invitation as we did in West Coast Hotel versus Parrish and Williamson v. Lee Optical." At oral argument, counsel for Planned Parenthood drew a distinction between personal liberties and the sort of economic liberties that were afforded judicial protection during the Progressive era. The theory being asserted, he claimed,
it is not broad due process in the sense in which the issue was raised in the 1930s. In the first place, this is not a regulation that deals with economic or commercial matters. It is a regulation that touches upon individual rights, the right to protect life and health, the right of advancing scientific knowledge, the right to have children voluntarily. We are not asking this court to revive Lochner against New York or to overrule Nebbia or West Coast Hotel.
Justice Douglas followed this lead in his majority opinion. We do not sit as a super legislature to determine the wisdom, need, and propriety of laws that touch economic problems, business affairs, or social conditions, he wrote. Quote, "This law, however, operates directly on an intimate relation of husband and wife and their physician's role in one aspect of that relation." Study guide. Does the text of the Constitution draw any distinction between economic and intimate or personal liberties? Theodore Roosevelt had made Lochner v. New York a campaign issue in his 1912 presidential campaign. Yet, it remained a rather obscure case until Griswold was decided in 1965. Indeed, Justice Black could not quite remember what it was about.
That's the one that held that was unconstitutional, as I recall it, for a state to try to regulate the size of loaves of bread.
No.
Keep people from being defrauded, was that it?
It was Justice Douglas's rejection of Lochner in Griswold that made Lochner notorious. Only after this 1965 case did the Progressive era decisions become known as the Lochner era. Second, Justice Douglas then recast Meyer v. Nebraska from 1923 and Pierce v. Society of Sisters from 1925 as decisions that involve First Amendment rights. However, these cases concerned economic as well as personal liberties protected by the Due Process Clause. In neither case did the court rely on the First Amendment. Third, Justice Douglas read the court's precedents to protect a right of privacy. He wrote, quote, "Specific guarantees in the Bill of Rights have penumbras formed by emanations from those guarantees that help give them life and substance." Astronomy guide. An emanation refers to a ray of light. During a lunar eclipse, the umbra refers to the darkest part of the shadow formed when the Earth orbits between the Sun and the Moon. The penumbra refers to the lighter part of the shadow, where some of the emanations from the Sun are visible. If you don't understand this analysis, you're not alone. To this day, critics of an unenumerated right to privacy widely deride Justice Douglas's use of emanations and penumbras. Justice Douglas continued, "Various guarantees in the Bill of Rights," he said, including the First, Third, Fourth, Fifth, and Ninth Amendments, create zones of privacy. Study guide. In light of footnote 4 of Caroline Products, why do you think Justice Douglas felt compelled to reference penumbras of the Bill of Rights? Perhaps he thought that linking the right of privacy to these express prohibitions of the Bill of Rights would keep his decision within the structure of footnote 4. Fourth, based on this analysis, Justice Douglas concluded that Connecticut's law, quote, concerns a relationship lying within the zone of privacy created by several fundamental constitutional guarantees. Therefore, the law is unconstitutional. There were three concurring opinions. Justice Arthur Goldberg agreed with Justice Douglas that Connecticut's law was unconstitutional. However, he provided an alternate analysis. Justice Goldberg wrote that the right of marital privacy can be supported by the language and history of the Ninth Amendment. The Ninth Amendment provides, quote, the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. He explained, quote, the Ninth Amendment shows a belief of the Constitution's authors that fundamental rights exist that are not expressly enumerated in the first 8 amendments, and an intent that the list of rights included there not be deemed exhaustive. Study guide. Is Justice Goldberg's concurring opinion preferable to Justice Douglas's majority opinion? Does the Ninth Amendment say anything about the scope of state powers? However, Justice Goldberg does not conclude that the Ninth Amendment protects the right to marital privacy in this case. Why not? The Ninth Amendment only places limits on the power of the federal government. Instead, Justice Goldberg cited the Ninth Amendment for the proposition that the text of the Constitution endorses the idea of protecting unenumerated rights. Justice John Marshall Harlan II, the grandson of the first Justice John Marshall Harlan, wrote an influential concurring opinion. He explained that, quote, proper constitutional inquiry in this case is whether this Connecticut statute infringes the Due Process Clause of the 14th Amendment because the enactment violates basic values implicit in the concept of ordered liberty. 3 decades later, in Washington v. Glucksberg in 1997, several justices would adopt the framework that Justice Harlan articulated in Griswold to limit the judicial protection of unenumerated rights. Justice Byron White concurred in the judgment. He wrote that nothing, quote, justifies the sweeping scope of this statute with its telling effect on the freedoms of married persons, and therefore, I conclude that it deprives such persons of liberty without due process of law. There were 2 dissenting opinions. Justice Hugo Black rejected the penumbras and emanations approach to the Bill of Rights. He found no right of privacy in the text of the Constitution. Quote, I like my privacy as well as the next one, but I am nevertheless compelled to admit that government has a right to invade it unless prohibited by some specific constitutional provision. Study guide. Does Justice Black's dissent track footnote 4 of Caroline Products? Justice Black charged the majority with forgetting West Coast Hotel and returning to the dangerous and discredited precedent of Lochner v. New York, a decision he had a hard time remembering the facts of in oral argument. Justice Stewart wrote a separate dissent. He thought Connecticut's law was uncommonly silly. However, he could find nothing in the Bill of Rights that renders the law unconstitutional. With Griswold v. Connecticut, the Warren Court cracked open the settlement about the scope of judicial review established by the New Deal Court in Caroline Products. In the next case, Roe v. Wade, the Burger Court would apply the right of privacy to prohibitions of abortion.